Today, I want to talk about what it means to sponsor an employee for an H-1B visa, or really another immigration type of visa. But today we're going to talk about what it means to sponsor an employee for an H-1B. Know that when you're talking about sponsoring an employee for an H-1B, it can be sponsoring an employee for their very first H-1B, in which case they probably have to go through the H-1B cap process. Or it can be that you're sponsoring them for an H-1B transfer, meaning they have held H-1B status previously, or they hold it now rather, and they're transferring from employer A to your particular company. And this particular live, we're going to focus on what it means to go through the H-1B sponsorship process for the very first time. So likely that will be somebody who is, let's say, on F1 student visa, who's working on OPT. They've never held H-1B status before, and you have to go through this thing called the H-1B cap and lottery. And there are all these timelines, and it's super confusing. You don't know what information you as the employer need, what information they need. So that's what we're going to talk about today. So first thing to know is if a foreign national employee, let's say somebody that you are employing right now, has never held H-1B status before, they are likely going to be subject to what's called the H-1B cap. There's a numerical limit, annual numerical limit of 65,000 new H-1Bs available every year, plus an additional 20,000 for US master's degree holders or higher. So it can be a PhD, a JD, whatever it is. So there's this annual limit. There's so many people who want a new H-1B every year that typically USCIS will conduct a lottery. That lottery is held in March. So the process is that the employer will submit a registration, typically with the help of an immigration attorney, to USCIS during the registration period, which is in March. It's typically about 3 weeks. The dates for 2024 have not been announced yet, but typically it starts around the beginning of March and ends about 3-ish weeks later. So the employer, again, typically with the help of an immigration lawyer, will submit this, what's called a registration. And we'll talk in just a minute about what that means. The registration process itself, we as immigration law professionals at Sumner Immigration Law, we try to make this process as streamlined as possible for both the employer and the employee. That is our job, to make sure that it goes through, to make sure it goes through smoothly, to make sure that we have all of the information. That being said, there is some basic information that's required for the registration process. Again, we'll talk about specifically what that is in just a minute. Then, if the H-1B registration that you submit in March is selected in the lottery, so the lottery is conducted at the end of March, and typically we start getting notices about individuals' registrations that were selected at the end of March, usually like March 25th, 26th. That general time frame. If the case is selected, then we can file what's called the H-1B petition between April 1st and June 30th. So we have a 90-day window to file. So we'll talk in just a minute about the elements of that, what that looks like, what the employer has to do, what the employee has to do. So let's talk first about the information. I'm looking at my screen to do a screen share here. The information that's required for the registration portion. The registration portion of the process is fairly straightforward, but again, typically employers will do it through to complete the registration with the help of an immigration attorney. So we're going to present full screen here, and I'm going to skip ahead. This is actually a webinar that we did last week. If you're interested in the recording of the full webinar, drop a comment on the platform that you're looking at right now, and we are happy to send you that, or you can email us. We're happy to send you a recording, or you can email us at info@sumnerimmigration.com. We're happy to send you the full recording. But this is the information that is required for the actual registration. So the name of the employer, legal name of the employer, the tax ID number, and we typically have that verified even at the registration process, because you'll have to have it verified to file the actual H-1B, the US office address, and the authorized signatory. So who is the person that's going to be signing the H-1B petition if it's actually selected in the lottery, and who's going to be authorizing or approving this registration that we submit. it's pretty straightforward information. And we try to keep it as simple, as streamlined as we can. We have a set system that we use to collect this information. Information for the H-1B registration that we need from the beneficiary, things like their name, gender, their master's degree information. If they have a U.S. master's degree, it's important at this stage that we have that information and that we verify that it qualifies as a U.S. master's degree program. For H-1B cap purposes, the U.S. master's degree has to be from a university that is accredited and that is not a for-profit institution. So that's something that we absolutely double check as part of the registration process. Also, information that we can get from their passport, like their passport number, country of citizenship, country of birth, which can be different. So that is the information that we need for the registration. It's possible that USCIS would change a little bit the registration process this year. There's some talk of changes to the process. So if that happens, it's possible we would need slightly different information, but it is pretty streamlined. So this is the information that we need, again, for the H-1B registration process. I'm going to stop sharing. No. That's the information that we need for the registration process. Like I said, it's pretty streamlined. And you might be thinking, okay, I can do this on my own. I can register on my own. Absolutely. If you want to register on your own, go for it. There are employers, we have employers over the years that actually do that successfully on their own, and then they come to us once the case is selected and it works. There are other employers who say, I don't want to mess this up. My foreign national employee has one chance at this, or maybe if they're lucky, 2 or 3 chances that they have STEM OPT or something like that. We do not want to mess this up. We want to make sure we get this absolutely right. And that's where we come in to make sure that everything is done absolutely correctly. And then there's lots of communication between our office and the employer contact. The employer contact has the responsibility as well. Once we enter this information into the USCIS system, they do have to confirm it. There has been what's called a handshake system, which means they have information that they meaning the employer, that they use to log in and to check the information on the system to verify it's correct, then we submit it. Once the registration is submitted, we confirm that information with, we let the employer know that everything is submitted, and then we keep them updated on the lottery process that happens at the end of March. With the lottery process at the end of March, like I said, typically that happens like a few days before March 31st. We let everybody know as soon as we have, everybody meaning the employers whose cases registrations have been selected, we let them know as soon as we have that information, because I know that this is really a stressful time for everybody involved, for the employer, for the foreign national employee, for everyone. You want to know if you're selected or not. So if a case is selected, we let you know as soon as we have that information, and then also kick off the process to get the petition process, the petition together to be able to file within that 90-day filing window. So let's talk about that. What does that look like? That process looks like the employer sending us some additional information and the employee sending us some additional information. We, as the attorney, other legal professionals, paralegals work with this, and other team members work with us to make this happen. But we as legal professionals, immigration law professionals, will look at that information and help you come up with a case strategy. So when I say case strategy, I'm talking about, we want to make sure that the position itself, if it hasn't already been done, hopefully it's been done as part of the registration process, but we want to make sure the position itself is an H-1B position, meaning a position that requires a minimum of a bachelor's degree in a specific field of study. We want to make sure that the job title aligns with that. We want to make sure that the job duties are clear, that USCIS will have a clear understanding of what the job duties are, and that it aligns with what the job title is and with what the standard occupational code is. So as part of the filing, there is the H-1B filing, there is a form that we have to complete on behalf of the employer and have certified by Department of Labor. There are certain attestations that you have to make as part of this process. And I, again, will share my screen here to talk about exactly what those attestations are. So on this document that I'm talking about that has to be certified by the Department of Labor, and it's something that we help you. We prepare the form based on information that you give us. We have you review it and approve it before we submit it to the Department of Labor. But on that LCA, labor condition application, which is different from the perm labor certification, we include the job title, the job site or work site location, the SOC code. So the standard occupational code comes from this kind of database that Department of Labor has. They do not have every single job title in their database that you can imagine. So for example, we have a lot of clients in pharmaceutical development. We had one time a client what their job title was dictionary data analyst. I, of course, had to do some research. We have lots of pharmaceutical development clients, but I had to get some clarification on exactly what that meant. And then it was a very strategic process to then align that to an appropriate SOC code that also was aligned with what Department of Labor thinks in terms of the degree requirements and the degree requirement that the client or the degree that the client had, and make sure that that's aligned with the wages that the employer is going to offer. So if you didn't understand all that, no problem. That's our job to make sure that all of the elements align, and we will walk you through that step by step to make sure that your case is set up to be as successful as possible. But there's a lot of strategy that goes into that. In terms of the employer attestations on the LCA, you're attesting that you as the employer are going to pay the prevailing wage or the actual wage, whichever is higher, that you're attesting that there are no adverse impacts to existing employees, there are no labor issues like strikes or lockouts, and that you will offer, if you terminate the foreign national's employment before the end of the H-1B period, an NH can be valid for up to 3 years, and you can extend for 3 years beyond that, but you're attesting that you will provide return airfare home, or at least offer that home if you have to terminate them for performance or because of a layoff before the end of the H-1B. So those are the things that the employer is attesting to on the LCA. So other things that the employer has to do, because it's always a question that I have with whether I'm talking to individuals who are about to approach their employer about having them sponsor them for the H-1B, or potential employers who are like, what does this involve? It does involve that LCA where you're testing that you're going to pay these certain wages and those other attestations that I mentioned. In addition, the employer will review forms. So we prepare the forms and the support letter based on the information that you give to us. So yes, we're going to ask for a detailed job description from you as the employer, and also possibly from the employee as well. They may have input into that, but it really needs to come from the employer. So based on that, on the wage information, the worksite location, we will prepare all of the required forms, ask you to review them, sign them, and send those forms back to us. You are not in charge of reviewing the forms. In addition, there are posting requirements. So the employer has to post what's called a notice of filing in connection to that LCA, that labor condition application that I just talked about. Again, we give you very detailed instructions on that and walk you through step by step to make sure that you're in full compliance with that as well. So it might sound like a lot, but we do everything we can to streamline it and to make sure that the process is as seamless and stressless. It's not going to be stressless, but less stress as possible, because we know that this is not the full-time job of really anyone at the employer or the individual foreign national. So we want to make it as easy as we possibly can, as transparent of a process as we possibly can. For the employee, we need some basic information like copies of their degrees, their transcripts, their resumes, and of course we use all of that as part of the strategic analysis that we do for the case. When the case is approved, we of course let the clients know, and then we have approval memos that we send out to let them know next steps, like this is valid for 3 years. We'll be in touch about 8 months-ish before the petition expires to renew it. We'll also, at a certain milestone, talk to you about the green card process if you decide to go that route. But the bottom line is that is the basic information that the employer needs, and that's the process that they would go through to sponsor an employee for H-1B status for the first time if they have to go through the CAP process and the lottery process. One other key point before I wrap up on this particular topic is the employer does have to pay the legal fees and the filing fees, government filing fees for the H-1B. There are certain exceptions, possibly arguments that could be made, but in general, the regulations state that the employer has to pay the legal fees and the filing fees. So that cannot be paid by the individual employee has to be paid by the employer. If you have questions about the H-1B process, other employment-based immigration process, if you'd like some fee information, if you have questions about a family-based process, let us know. Send us an email at info@sumnerimmigration.com, and we are happy to help you. Otherwise, I will be back on live next week, next Tuesday at noon. Look forward to seeing you then.